Appeal in the matter of Koza Ltd and another named Koza.
Hello, it's my lady. I appear with Mr. Trotter for the appellants, Koza Ltd and Mr. Ipek. We are grateful to the court for permitting Mr. Trotter to appear remotely from Australia.
Well, in the circumstances, it seemed, at least, an exceptional case.
Very great.
What I propose, I think you think my clerk's already mentioned this, but we sit from now until 1:15, and we'll have half an hour for lunch till 1:45, and then we'll sit to either 4:15 or 4:30, depending upon people's appetite, and for appetite for continuing, that is, rather than for lunch. And on the assumption that on that basis, we if we have to, we can sit at 10 tomorrow, but perhaps we can review it at the end of the day.
My Lord, I'm grateful. My Lord, to complete the introductions, we have Mr. Crowe and Mr. Catlin for the individual respondents, the trustees. Through the trustees, they purport to represent the corporate respondent, Koza Altin. By way of housekeeping, the court should have, I hope, a core bundle and a supplemental bundle divided into 2 volumes. There is also a joint authorities bundle divided into 3 volumes. In addition, there is a ladder marshal application from the respondents and a separate slim volume.
It's not resisted,
is it? It is not resisted, no. My learned friend Mr. Crowe and I have discussed a timetable for submissions. We have agreed that I will open the appeal and address his respondents' notice points today. He will then answer those submissions finishing 4 p.m. tomorrow, and I will reply in what remains of the day. By way of overview of our core case and how I propose to develop my submissions.
We've got a transcript, haven't we?
We have. I think it's an overnight transcript rather than a live one.
That's fine. This is helps us in terms of how much writing we need to do. Thank you.
My Lords, my lady, by way of overview, this is an appeal with the court's permission against orders of Mr. Justice Trower made in September last year, refusing our application for permission to serve out the claim in the 2021 proceedings and dismissing our application to strike out the Defence and Counterclaim served in the name of Koza Altin in the 2016 proceedings. At the heart of those 2 proceedings and this appeal is what has become known as the authority issue. The issue is whether the trustees have authority in this jurisdiction to act on behalf of Koza Altin in its capacity as shareholder in Koza Ltd. We say they do not. That is because their appointments derive from a corrupt judgment of the Turkish court, the sewer judgment, and it would be contrary to English public policy to recognise that judgment and the appointments made on the basis of it. There was no dispute before the judge that there are serious issues to be tried as to whether the sewer judgment is in fact corrupt and contrary to English public policy. It's paragraphs 82 and 83 of his judgment, Core Bundle 11, page 120. There was also no dispute before the judge that the English court is the appropriate forum to try that issue. That's 53 of his judgment, Core Bundle, tab 11, page 114. The judge also concluded that our claim would pass through the gateways under CPR Practice Direction 6b, paragraph 3.1, in essence, because the claim is for an injunction restraining acts in this jurisdiction. I'll come back to that in due course because it arises on one of the respondent's notice points. The gateway issue is dealt with in the judgment at 120.
Well, the argument is that even if the directors were in Turkey, the instructions would be given to act in England.
Indeed.
So they're passed through, so for the purposes of the injunction gateway, that gateway is satisfied.
Indeed. That was our argument.
It's as short as that, isn't it?
Indeed. The judge nonetheless summarily dismissed our case on the authority issue. He did so because he was persuaded by my learned friends that our complaints about the sewer judgment, however well-founded in fact they may be, are legally irrelevant to the determination of the authority issue. And the judge's core reasoning was to approach that as a choice of law question. He reasoned that Turkish law governs, and because the directors have authority to represent Koza Altin as a matter of Turkish law, that disposes of the authority issue in the English court. That's paragraph 114, among other places in his judgment. Core bundle, tab 11, page 12728. 3 observations about the context in which the judge reached that conclusion. First, it was not the judge's task to try the authority issue. His task was not to try the authority issue. It was to determine whether there are serious issues to be tried, whether of fact or law, such that it would be proper to permit service outside the jurisdiction. The same test applied to the request for summary determination of the authority issue in the context of our strikeout application. I will take the court to the authorities on this in due course, that they make clear that it is not normally appropriate in a summary procedure to determine controversial questions of law in a developing area. It is ordinarily more appropriate that the law be determined once the facts are found. The question of law dealt with by the judge was a controversial one in a developing area of the law, and we say it was ill-suited for summary determination. The second contextual point is that the authority issue is a narrow and novel one. Narrow because in most cases the representatives of a foreign company will be appointed by private processes involving the company's stakeholders, whether it's directors or its shareholders. That is not this case. Here, the appointments are made by or depend on a judgment of the foreign court. The point is novel because the parties have been unable to identify any English or Commonwealth authority that specifically addresses the question how the English court should appoint such appointments. Should the court treat it as a choice of law question, or should the court instead treat it as a question turning on recognition or not of the relevant foreign judgments?
When you say that, you mean there's no authority directly in point? What's said by Mr. Crowe is Williams and Humbert gives you
and the short answer to that,
right.
The short answer to Williams and Humbert is it has nothing to do with this case. It is a case about the rules concerning recognition of foreign legislation. I'll come on to this, but it's a case about the normal deferential court approach that the English court adopts under the Foreign Act of State doctrine to foreign legislation.
There is foreign legislation in this case, but you say it all goes back to the sewer judgment.
Indeed. That doctrine, the Foreign Act of State doctrine, has no application to foreign judgments. Foreign judgments attract a very different principle, the one we rely on, a principle of domestic law concerned with recognition, subject to well-established exceptions, fraud, natural justice, and so on.
Well, the Foreign Act of State doctrine doesn't apply to foreign judgments. It's expressly dealt with by Lord Lloyd Jones in Central Bank of Venezuela, isn't it?
Indeed, which was handed down after the judgments.
Yeah, I understand that.
But indeed, that point is now settled beyond dispute. Now, the judge said the issue, choice between approaching a matter as a choice of law question or as recognition of judgments, was not straightforward. That's paragraph 103 of his judgment, core bundle, tab 11, page 125. We respectfully agree, the issue is not straightforward.
Give me the paragraph number again, Mr.
It's paragraph 103.
103, thank you.
Core bundle 11, page 125. And we agree the issue is not straightforward, and that is illustrated by the absence of authority directly on point, the fact that the issue was argued over 2 days in the court below, and the fact that it will be argued over approaching 2 days in this court. The third contextual point is this. Faced with a narrow and novel point, and without any authority directly bearing on it, the judge attempted to answer it, as he had to, if he was not going to leave it to trial, as a matter of principle. And as my Lord the Chancellor observed, he reasoned that the authority issue could be resolved, in the judge's words, on a principled basis, by analogy to Williams and Humbert. That's paragraph 103, page 125 in the court bundle. That was the single authority he cited in support of his conclusion. I'll address the court on it in due course, but Williams and Humbert is completely irrelevant to the issue in this case. Williams and Humbert was a case concerned with the well-established rule against enforcing foreign penal law, in that case, Spanish legislation. It had nothing to do with the court's approach to foreign judgments. No foreign judgment was in issue in that case. The House of Lords considered none of the authorities, that I will show the court, which bear on the court's approach in cases involving foreign judgments. And furthermore, as my Lord the Chancellor observes, subsequent authority has made clear that the Foreign Act of State doctrine, which was of some relevance in Williams and Humbert, has no application in the context of judgments. And I'll go to this in due course, but as Lord Lloyd Jones for the Supreme Court put it in the Venezuela case, at paragraph 159 of his judgment, courts in this jurisdiction are more willing to investigate whether a foreign court is acting in a way that meets the standards expected of a court, and whether there has occurred, or is likely to occur, a failure of substantial justice. For this reason, foreign judgments fall to be assessed under different rules from those applicable to legislation and executive acts, and are simply less impervious to review. For the court's note, that important passage is Authority Bundle 2, tab 30, page 1170. Now, the judge did not have the benefit of that important guidance and the distinction in principle that the Supreme Court identified in that case. And part of our core argument in this appeal is that the judge's conclusion and reasoning cannot be reconciled with it. Against that background, the main issue in this appeal is the same point of principle that confronted the judge. Should the English court recognise a person's asserted authority to represent a foreign company when it derives from a corrupt foreign judgment? We say the English court should not, for two reasons. First, to decline recognition in such a case would accord with the court's approach in other contexts where a person asserts here a right or a status deriving from a foreign judgment. In those contexts, the issue does not depend on the foreign law. It depends on whether the relevant foreign judgment is entitled to recognition under English principles. And I will develop that submission by reference to the law in the context of judgments in rem, determinations of marital status, and appointments of receivers and office holders. And what the court will see is that in all of those contexts, the same pattern of reasoning applies. Where the relevant status derives from a foreign judgment, the court applies its rules on the recognition of judgments, including, critically, exceptions for public policy. What the court does not do is to approach the matter as a choice of law question, which is what the judge did in this case. And our submission is that there is no principled reason for treating differently a case in which a person's authority to represent a company as its director derived from a foreign judgment. That is an issue which stands or falls on whether the judgment is entitled to recognition in accordance with domestic principles. It does not depend on the application of the lex incorporationis, the law of the place where the company is incorporated. And it is important to appreciate the limited scope of the principle for which we contend. As in every case involving recognition of judgments, the fact that the English court declines to recognise the foreign judgment says nothing about the validity of the judgment either in the foreign jurisdiction or in any other jurisdiction. It just deals with the position in England. So take, for example, the property cases or the status cases. The consequence of declining recognition in England is that the property may be regarded as owned by a party, or a party may be regarded as married or not married, or as an office holder in the foreign jurisdiction, but will not be so regarded in England. There is no principled reason why the same should not apply in this case if we prove our factual case. And that is why the authority issue is confined to the authority of the individual defendants to act for Koza Altin in this jurisdiction. Now, my learned friends argued below that that outcome would be so impractical as to indicate that the court should not decline to recognise their authority under the lex incorporationis. But that appeal to practicality was rejected by the judge. That's paragraph 119 of his judgment. As the judge observed, if the court thought it was necessary to grant relief to protect Koza Altin's position in this jurisdiction, having resolved the authority issue in my client's favour, it could do so, for example, by appointing a receiver. So that's the first reason, the analogy we draw to the in rem cases, the status cases, and the office holder cases.
Yeah.
The second reason that we advance in support of our analysis is that it accords with the fundamental distinction drawn in the Foreign Act of State case law between the English court's approach to foreign legislative or executive acts on the one hand and judicial acts on the other. And the position there is now clear following the Venezuela case. For legislative and executive acts done in the relevant state's territory, the English court generally recognises them and will not question them, although there is a public policy exception, the scope of which continues to be developed in the case law. And those principles provide the context for Williams and Humbert. But for foreign judicial acts, the approach is fundamentally different. Here the position depends on domestic principles, on recognition of foreign judgments, and that brings with it the court's ordinary right to inquire into whether the foreign judgment was corrupt or obtained in circumstances which otherwise engage the court's policy. And the rationale for the distinction, again, clear from the Venezuela case, is the rule of law considerations that apply in relation to foreign judgments. And that is why they are simply less impervious to review. My Lords, my Lady, with that overview, I propose to develop my submissions in three parts. First, I will develop our core case that the authority issue turns on the rules about recognition of foreign judgments and take the court to the key authorities we rely on. That core case provides the building block for our grounds of appeal. Then in the second part of my submission, I will develop those grounds of appeal and explain why we say the judge's conclusion and reasoning, including his reliance on Williams and Humbert, was wrong. And thirdly, I will address the points taken by my learned friends in their respondent's notice. And I think there are 5 grounds to deal with there. Yeah. My Lords, my Lady, starting with our core case on the point of principle in the appeal. Let's begin with judgment in rem and other determinations of status. And the leading authority here is the House of Lords decision in Castries and Imrie, can we turn that up? It is Authorities Bundle 1, tab 5. Let me summarise what it was about. The case concerned an English ship sold under a judgment of the French court while it was in port in France. Sale was ordered to settle a debt incurred by the ship's captain for necessaries. The ship was sold under the French court's order to the defendants, Imri, who were later sued in England by the plaintiff, Castrique, in an action to recover the ship. Castrique brought the action in England on the basis that he had a prior title under English law derived from a mortgage of the ship granted by the original owner before the French court gave its judgment. When giving that judgment, the French court had sought to take account of any objections to sale from the ship's owners, but the original owner of the vessel did not appear. And while Castrique did appear to make an objection, the French court erroneously concluded that Castrique had no valid title under English law. Against that background, the House of Lords asked the judges to answer the question whether Castrique was entitled to recover the ship from Imri. Mr. Justice Blackburn gave the majority opinion on that question and concluded that Castrique was not so entitled. His Lordship reached that conclusion on the basis that Imri acquired good title under the French judgment, and the French judgment was entitled to recognition in England. And his Lordship treated the issue as turning on the recognition of the French judgment, not as a choice of law question. And that was an important distinction in that case, because approached as a choice of law question, the law of France, the situs of the ship at the material time, would have applied English law to determine Castrique's title. And as a matter of English law properly applied, Castrique's title was paramount. But that was all irrelevant on Mr. Justice Blackburn's analysis. The issue was simply whether the French judgment should be recognised by the English court. If we can go to page 432 of the report, the court sees in the final paragraph Castrique's argument, which was that the French judgment should be disregarded because it was founded on a misapprehension of English law. Mr. Justice Blackburn, for the majority of the judges, dealt with that argument at page 433 of the report. Can I ask your Lordship and your Ladyship to read the sidelined passage on page 433? Emphasise 2 points here. First, Mr. Justice Blackburn treats the question as turning on recognition of the French judgment, not choice of law. If it had been a choice of law question, then applying the relevant French and English law, Castrique would have won. Second, Mr. Justice Blackburn identifies fraud as a basis for treating the French judgment as void. He says fraud will indeed vitiate everything, but the case was not one of fraud, so ultimately the exception did not apply. And Mr. Justice Keating, who's the other judge, he concurred in the result, but for different reasoning. His lordship regarded the French judgment as in personam and erroneous on its face, and so he did not consider it determinative. Now, unpacking that a little, his lordship's reasoning appears to have been that the French judgment did not purport to determine anything as against Castrique, and insofar as it proceeded on the basis that Castrique had no title under English law, that was wrong. However, Mr. Justice Keating was prepared to infer that as a matter of French law, a sale under judicial order would be effective to confer good title on an innocent purchaser, such as Imri. In other words, Mr. Justice Keating did approach the matter as a choice of law question. He alone among the judges took that approach.
But the House of Lords agreed with Mr. Justice Blackburn. didn't
Indeed.
they? So what
And that's
Justice
where I was
Keating
going
said
next.
is very interesting, no doubt, not really of any relevance.
Indeed. But what it does show, my lord, is that there was before the House of Lords the two alternative analyses that confronted the judge in the present case. There was the recognition analysis of Mr. Justice Blackburn for the majority and the choice of law analysis of Mr. Justice Keating on his own. And the House of Lords endorsed Mr. Justice Blackburn's approach. They too treated the case as depending simply on recognition or not of the French judgment. And just to give the court the references, in the Lord Chancellor's speech, the reasoning is sidelined at page 445 to 6 of the report. We see the same approach in Lord Chelmsford's speech, page 446 to 7 and 8, and similarly in Lord Collinsay's speech, page 448. My lord, my lady, the next authority we go to is the AK Investments case in the Privy Council. It's at tab 18 in the same bundle. We rely on AK Investments for 3 points. First, the correct approach for the court to adopt when assessing whether, for service out purposes, a disputed question of law gives rise to a serious issue to be tried. Second, the conclusion that the English court is not prevented from examining whether a foreign court is corrupt, and that the Foreign Act of State doctrine has no application to judicial acts. Third, the conclusion that it is at least arguable that a foreign judgment in rem may be refused recognition on public policy grounds. Now, just to summarise what AK Investments was about, the case involved a dispute between two Russian camps concerning the ownership of Bytel, a Kyrgyz company. The KRG companies were in one camp. They initially held the shares in Bytel. There was then a coup d'etat in Kyrgyzstan, and the owners of the KRG companies, who were associated with the former regime, left the country. Subsequently, a company in the other camp, Fellows, obtained orders from the Kyrgyz court that it be registered as shareholder of Bytel in place of the KRG companies. The shares in Bytel were then transferred by executive order to another company, Reserves Petmet, and then onto a series of other companies. The court's note, that's dealt with at paragraphs 28, 29, 38, 42, 43 and 50 of the judgment, setting out the background facts. Now, the KRG company's position was that the Kyrgyz courts were corrupt, that their orders were obtained by fraud, and that the share transfers were done in breach of an arbitration agreement and in breach of injunctions of the English and BVI courts. The KRG companies were sued in the Isle of Man in an action to enforce a debt under another Kyrgyz judgment. The KRG companies defended and counterclaimed for damages on the basis that the Kyrgyz judgment was not entitled to recognition in the Isle of Man because it was obtained by fraud. The KRG companies also applied for permission to serve out a counterclaim against Fellows and the other recipients of the Bytel shares, seeking relief in respect of an alleged unjust enrichment by the receipt of those shares. Underlying that counterclaim was the contention that the Kyrgyz court orders under which the share transfers had taken place were not entitled to recognition in England on public policy grounds. The defendants to the counterclaim maintained that permission should be refused because they said the claim was bound to fail on the merits. That was said on various grounds, including that the defendants were entitled to the shares under the Kyrgyz court orders, and those orders, being in rem, was said could not be impugned in England. Now, the Manx court eventually granted permission to serve out. The defendants appealed to the Privy Council, and the appeal was dismissed. Lord Collins gave the board's advice, the board also including Lords Phillips, Mance, Kerr and Clark. And we can pick up the relevant reasoning at paragraph 71 in Lord Collins's judgment. And his lordship is here summarising the general requirements for service out. The first of which is that the claim raise a serious issue to be tried on the merits, a substantial question of fact or law, or both, as Lord Collins describes it. Now, the passages that follow are mostly concerned with the necessary or proper party gateway, and I don't need to trouble the court with those. But can we turn forward to paragraph 81 under the heading bound to fail, serious issue to be tried and questions of law? And can the court please read 83 down to 86 over the page? we say the test here is pithily captured by the quotation against letter H on page 1825. It is no part of the court's function to decide difficult questions of law, which call for detailed argument and mature consideration. That's for trial. It's not for the court when determining whether to permit a claim to be served out so that there may be a trial. So that's the first point. The second point we take from AK Investments is the court's approach to the assessment of justice in the foreign jurisdiction. Now, one of the allegations we make in the present case is that justice generally has broken down in Turkey and had generally broken down at all material times. And that is similar to one of the allegations that was made in the AK Investments case. And one of the defendant's arguments in response, and we see this recorded at 96, is that it was not possible for the court to adjudicate upon such an allegation of endemic corruption. And that was said to flow from the Foreign Act of State doctrine and from the judicial restraint principle in Boots Gas. Lord Collins rejected that argument. His lordship deals with the authorities at 97 to 100. I don't need to trouble your lordship with those, but it is helpful to see the way the principle is put at paragraph 101. Can I ask your lordship and your ladyship to read that, please? 101. As I will show the court in due course, that statement of principle was approved by this court in the UCOS case, and it has since been approved by the Supreme Court in the Venezuela case. The third point we take from AK Investments concerns the court's approach to the Kyrgyz judgments providing for the transfer of the Bytel shares. We pick this up at paragraph 109 under the heading Fraud and Foreign Judgments, the principle in Abeloff and Oppenheimer. Lord Collins identifies that principle at 109. It is the principle that in the context of recognition and enforcement of foreign judgments at common law, the judgment may be impeached for fraud even though no newly discovered evidence is relied on, and even though the evidence may have been put to the foreign court and rejected. His lordship then identifies at paragraph 110 the various arguments identified by the defendants in that case as the bases for avoiding application of the Abeloff principle. We are concerned with the third of the arguments recorded at paragraph 110, the argument that a judgment in rem could not be impeached because it has proprietary effect. Lord Collins rejected that argument.
Hang on a second.
So that's the argument. In rem judgments can't be impeached for fraud because they have proprietary effect. And Lord Collins rejects that argument at paragraphs 120 and 121. Can I ask your lordships and your ladyship to read 120 and 121? Now, of course, Lord Collins did not try to resolve the question. He was just concerned to ascertain what was arguable. But he held to be arguable the proposition that the company's shareholders were not to be determined by reference to Kyrgyz law. If you'd applied Kyrgyz law to that question, there'd have been a very short and simple answer. The shareholders were fellows and the people who derived title from them. No, what was arguable was that the true shareholders, from the English court's perspective, were the KRG companies, because the Kyrgyz judgment that was said to have divested them of their shares was not entitled to recognition in the Isle of Man for the various reasons identified at 121. So that's the in rem cases. I turn next to the court's approach to foreign determinations of marital status. And the same approach applies here, where a party claims a particular marital status under a foreign judgment. The issue does not turn on choice of law rules for the validity of marriage. It turns on whether the foreign judgment is entitled to recognition in line with domestic principles. That's borne out again by House of Lords authority. This is the von Loreng case. That's at tab 7 in the same authorities bundle. That was a Scottish appeal, but there is no difference in principle between the relevant principles of Scots and English law. The case involved movable property in Scotland, to which competing claims were made by Mrs. von Loreng on the one hand and the administrator of Austrian property on the other. Now, the administrator was an office holder under a statutory scheme set up after the war to administer the property of Austrian nationals in the UK. If Mrs. von Loreng was an Austrian national, the administrator would be entitled to the property under the statutory scheme. Otherwise, she would be entitled to her property in the ordinary way. The administrator's case in the proceedings was that Mrs. von Loreng had acquired Austrian nationality by reason of an alleged marriage to an Austrian national, Herr von Loreng, as he's identified in the judgment. That alleged marriage was said to be celebrated in Paris, and the couple lived together as man and wife in Germany, where they were domiciled. Mrs. von Loreng's case was that the Paris marriage was a nullity. She and Herr von Loreng obtained from a court in Germany, their domicile, a decree declaring the marriage a nullity. The administrator was not party to those German proceedings, so no question of res judicata or issue estoppel could arise. The question for determination instead was whether the German judgment should be held binding by the Scottish courts for the purposes of excluding the administrator's averments from the inquiry. At first instance, the Lord Ordinary held that the German judgment did dispose of the case. He repelled the administrator's claim for proof and preferred Mrs. von Loreng to the property. So in short, the German judgment was a complete answer to the case, and there was no need to try out the allegations as to the validity or otherwise of the Paris marriage. On appeal to the First Division, the majority reached the opposite conclusion and remitted the matter back for proof on the averments. The House of Lords allowed the appeal and restored the Lord Ordinary's decision. It held unanimously that the German judgment was a judgment on status in the nature of a judgment in rem and was entitled to recognition in Scotland in circumstances where the German court was competent to give such a judgment because it was the court of the party's domicile. Now, in line with the property cases, to which their lordships referred by analogy, the court did not treat the question of status as a choice of law question. It instead treated it as depending on the recognition or not of the German judgment. And if we can turn first to Viscount Haldane's speech, the core reasoning is at 652. Can I ask your lordships and your ladyship to read the sideline passage? Once fraud and collusion were put to one side, the real question was recognition. Did the German court have international jurisdiction to give a judgment at that time? Viscount Hamdane went on to hold that it would. We see at the top of page 655, the first full paragraph on that page, Viscount Haldane reasons by analogy with Castrique and Imlay. Then,
Sorry, I wasn't keeping up. Where is the reference to Castrique? Oh, 655.
655, I'm so sorry, my lord. It's at the top of the page, the first full paragraph. And there follows a discussion of how cases in the context of marital status are to be characterised in rem, in personam or not. That doesn't detain us for present purposes. But I do need to show your lordship a passage on page 659 towards the bottom of the page. And here Viscount Haldane reasons by analogy to Pemberton and Hughes, which is of course the leading authority on judgment in personam. Your lordships and your ladyships see against the sideline passage. It says this: our courts never inquire whether a competent foreign court has exercised its jurisdiction improperly, provided that no substantial injustice has been committed. And it is that proviso, substantial injustice, that brings into play corruption, fraud, and other public policy grounds for non-recognition of the foreign judgment. Viscount Dunedin concurred. He too drew on Pemberton and Hughes. If the court can turn ahead to 663. Can I ask your lordships and your ladyship to read the sideline passage right down to the foot of the page? The other members of the appellate committee concurred with the opinions of Viscounts Haldane and Dunedin. I don't need to take your lordships and your ladyship to those. Now, the principles in Von Lorang have been applied on many occasions since then. We give examples at paragraph 43.3 of our appeal skeleton. In some of those cases, involving orders of the Maltese courts, as it happens, the English courts have held that although the foreign court was competent to declare the marriage a nullity.
Sorry, what paragraph of your skeleton?
43.3. and Gray and Formosa is the first of the Maltese cases. And they hold that although the Maltese courts in those cases were competent to declare the marriage a nullity, the English court would nonetheless decline to recognise the Maltese judgments on public policy grounds. It's exactly the same pattern of reasoning. The annulment cases do not involve the enforcement of a foreign judgment, nor do they rely on it for the purpose of establishing res judicata. What these cases involve is a party asserting a status conferred by a foreign judgment. So in von Lorang, the wife's case was that the German judgment annulled her marriage and conferred a new status on her. And that in turn had implications for her nationality, so as to allow her to assert property rights in Scotland. She could only do that because the German judgment was entitled to recognition in line with the Scottish court's rules, including rules as to public policy.
So it's to do with recognition of the judgment, not enforcement.
Indeed. We come next to the office holder cases, and the court will see the same pattern of reasoning here, where an office holder appointed by a foreign court seeks to rely on her status as such to assert rights in the English court. She can only do so if the relevant judgment is entitled to recognition here. Can we turn to tab 4 in the same bundle? These are extracts from Lightman and Moss on the law of administrators and receivers of companies. We start with paragraph 30027, which is on page 109 of the authorities bundle. And the learned authors begin their analysis with foreign appointments out of court. They observe at the outset that the English court has never directly considered the issue, but they advance the following submission between the hole punches. They say, where a receiver is appointed under a law other than the law of a part of the UK, in respect of the property of a corporation, and in consequence of the corporation having created a charge, which as created was a floating charge, he may exercise his powers in England if the exercise of those powers is authorised by the law of the country in which the company is incorporated. So for out-of-court appointments, the submission being made is that the appointee's authority is treated as raising a choice of law question to be answered by the law of the country in which the company is incorporated. And the authors go on to make the point that that reflects the general principle that the law of the place of incorporation determines who is entitled to act on behalf of the corporation. So that's the position for out-of-court appointments. The authors deal with court appointments at paragraph 30032. And they make the point that while the case law is still developing, I'm quoting now from the foot of the page, it is clear that the principles are different from those which apply to determine the recognition of a receiver appointed pursuant to a private appointment.
Where are you reading from?
I'm reading from the foot of page A110 of the authorities bundle.
Yeah, I'm watching.
The sentence beginning, however.
Yeah.
However, it is clear that the principles are different from those which apply to determine the recognition of a receiver appointed pursuant to a private appointment under foreign law. The difference arises because, in principle, when recognition of a receiver appointed by a foreign court is involved, the English court must satisfy itself that the foreign court was jurisdictionally competent to make the appointment according to relevant principles of English private international law. Consequently, it becomes necessary to determine when English law will regard a foreign court as possessing such competence. Where such competence is established, and there are no applicable general principles of conflict of laws precluding recognition, comity requires recognition to be afforded. Then they draw the contrast. In the case of a private appointment, the validity of the appointment must be strictly proved and comity has no place. We respectfully agree with the authors. There clearly is a difference between the approach to appointment under the foreign law, out-of-court appointments, and appointment under a foreign judgment. And the difference is the same difference the court sees in the property cases and in the marriage cases. It is the difference between a party who asserts a right or a status derived from foreign law on the one hand, and a right or status derived from a foreign judgment on the other. And in the latter case, the party can only assert its rights under the foreign judgment if that judgment is entitled to recognition in line with domestic principles. And that includes public policy principles. The authors addressed that point at paragraph 30-037. Can I ask your lordship and your ladyship to read that? It's on page A112 of the authorities bundle. So the authors there give re Schemmer as an example, a case where the foreign court's order was thought to result in the enforcement in England of a foreign penal law, and that could not be done in this court. We submit that exactly the same approach would apply if the relevant foreign judgment had been procured by fraud, or was corrupt, or otherwise contravened English public policy. Now, to make good that point, I will refer the court to the Rebed-Sharmoff cases, which were handed down again after judgment under appeal in this case.
Do you want to do that after a break?
Indeed.
Scott, thank you very much. We'll break for half an hour. That's fine. Thank you.
Court rise. Right, I'll just stop the live.